SJC-10345, Commonwealth versus Hurley.
Good morning. Is it Ms. Demond? Demond?
Yes.
Good morning.
Good morning. May it please the Court, my name is Sharon Demond and I represent the defendant, Mr. Peter Hurley, here today. We're here on a number of issues, and I'll start with the first one, and the first one being the erroneous admission of prior recorded statements, specifically statements made during a dangerousness hearing by a complainant that was later deceased and unavailable at trial.
Could I just ask you?
Go ahead.
It's a factual question. Two of them, actually. At trial, how? Because the Commonwealth has attached the whole dangerousness hearing. So did the whole transcript go in? What went in? What was read into evidence?
The testimony of Rose Bouvier is the only thing that went into evidence.
The direct and cross?
The direct and cross, yes, Your Honor.
The entire direct and cross, or excerpts of the direct and cross?
To my knowledge, the entire direct and cross.
And was it also, that second question was it also an exhibit that went to the jury?
Yes, they were produced in form of transcriptions.
And the jury, it was marked, it wasn't just that they were reading along while it was being said. It actually went into the jury room with them as an exhibit.
I apologize, Your Honor. I believe that was the excerpts of the conversation during the jailhouse that went to the jury as transcript. This testimony was just read to the jurors.
Okay.
And it was the entire testimony?
Yes, minus the testimony of the police officer, which was present at the time of the trial.
Was there any, while it was being read or before, did you represented the defendant at trial?
No, Your Honor,
okay.
I did not.
That's right, you didn't. And I'm going to forget his name.
Peter Hurley?
Did he ask the judge to exclude portions because, you know, if this person were testifying live, it just wouldn't be admissible? Was there any effort to do that?
There was absolutely. There was a hearing, actually.
No, I don't mean the issue about was it prior recorded. I just mean if you just take what was said, there are questions and answers that, as a matter of evidence, specific questions and answers wouldn't be admissible. Was there any, within the confines of it, was there any discussion about, well, if you're going to let it in, you should at least keep out that because it's not admissible evidence?
I don't believe so, Your Honor. I think the main objective was to the testimony itself, whether or not it was prior, yes.
What was the time frame of the jailhouse conversations? Was it, I assume, before the 58A hearing?
No, Your Honor. It was after the 58A hearing while he was waiting for an...
That's right. It was after, but, okay, so it was after, but...
But while he was waiting for an indictment.
Okay, all right.
If I may. As this Court is aware, the Sixth Amendment...
At the 58A hearing, did the Commonwealth seek to establish the defendant's dangerousness by presenting the evidence of the crime? Was that one of the bases for the Commonwealth saying this guy is dangerous and we want to lock him up?
Yes, Your Honor. The basis of dangerousness was that if he were to be released, he would be a danger to the...
Because of what happened that night?
Because of the assault and battery.
Okay, so if that's so, then wasn't the credibility of this woman witness the key issue with that trial? Because, I mean, at the dangerousness hearing, because if she's not to be believed, then that didn't happen, and the guy wasn't dangerous.
No, Your Honor. I would disagree with that characterization. The main objective or the main issue of the dangerousness hearing was whether or not the defendant will come back at the next hearing. A secondary, if he was released, whether or not he'll be a danger to Ms. Bouvier. Now, to that end, Your Honor, what the defense was trying to establish was that these three people were involved in a drunkard's stupor. Now, whether or not this assault and battery happened was not the objective at the dangerousness hearing. The objective, I would suggest, Your Honor, was that whether or not if this defendant was released, he would go back and continue what he had started, which is what makes the motivation to cross distinguishable than the trial itself. During the course of the trial, of course, the conduct itself and whether or not there was guilt or innocence and whether or not the Commonwealth could prove beyond a reasonable doubt every element of the crime would come at issue, versus during the course of the dangerousness hearing, the main issue was whether or not the release of this defendant would then pose a danger to this particular complainant.
I'm not sure I follow your distinction. You said the main objective of the defendant was whether the defendant would, or the main objective of the hearing was to determine whether the defendant would continue to do what he started to do the night before, or whenever it was, some nights ago. So isn't didn't the Commonwealth have to establish what he did then? I mean, that's the key to the whole thing. If he wasn't dangerous then, he won't be dangerous when he's released.
The Commonwealth, I would agree with you that the Commonwealth had to establish that he did somewhat.
What they said he did.
Yes, what they said he did.
And that's
However,
the same thing at trial. So then the issues are the same.
the issues are the same. The issues may be the same for the Commonwealth, but they're distinctly different for the defense, which is the issue here, whether or not there is motivation, the same motivation, same issue for cross-examination.
But didn't you try to prove, wasn't one of your attempts to prove that he wasn't so bad that night? They were all friends, and, you know, she hit him, and they always joke around like this.
Well, first, I was not the trial attorney. But
you
I would suggest that the trial attorney, yes, precisely that it was not so bad. Maybe they all got into this drunken stupor and know he wouldn't be a danger when he's released. But opposed to trial, the objective of the trial counsel would be the credibility of this victim witness, that whether or not this happened at all, or in the alternative, whether the Commonwealth can prove the elements against the defendant that this happened or not.
That's right. The elements that he did.
That he did commit the battery.
Issues are the same at both the hearing and the trial.
Well, the issues of credibility and the bias were not addressed entirely in the dangerousness hearing. It was slightly touched upon by the defense counsel, saying you were suspicious of him being out with another woman. Yes, and that was the extent of it. However,
and you were really mad. I mean, there were. Well, you may be right that at trial, had this witness lived and been able to testify at trial, the cross-examination probably would have been more extensive, may well have been, may have probed some different areas, but that's not the test as to whether or not the earlier testimony is admissible, that it would have been in complete conformance with what the examination might have been at trial, just whether the motivations are similar.
Exactly, and the motivations would come from the area of probe, whether or not the defense counsel would be having the same motivation to probe in that area during the dangerousness hearing rather than the trial. And that's the heart of the case where during
But there
the
are
course
lots
of
of preliminary hearings, probable cause hearings, in which, indeed, the witness gets up and testifies about what happened, and there is some cross-examination on the subject. Then the witness dies before trial, and that testimony is often offered into evidence. And it may be that the motivations at probable cause hearing would be different than at trial. You might want to do more or different things at trial, but that doesn't mean you didn't have an opportunity at the probable cause hearing to cross-examine the witness on these subjects, so that there wouldn't be some motivation to do that.
Yes, right. There was opportunity. That is not there was opportunity for cross-examination. But in the context of a probable cause hearing, there has been distinctions made whether or not there was probable cause to commit a crime, which is very similarly the same issue as the trial in opposed to guilt or innocence versus probable cause, that whether or not the person committed the crime. In a context of a motion to suppress hearing, it has been held in Stevens' case by the appeals court that where the probable cause was the issue of the suppression hearing versus the issue as trial was the guilt or innocence, then those are not enough motivation or similarity of issues and then enough motivation.
I'm sorry, tell me this again. If there is a hearing on a motion to suppress an eyewitness identification,
Yes.
in other words, the defendant is claiming that the victim's identification of him was improper in some fashion, and so the witness gets on and testifies about I take it, about the identification and how he or she identified the defendant, and presumably what happened that led to the identification. That testimony would be admissible at the trial if she died, wouldn't it?
I agree with that, Your Honor, if the issue at trial was the identification of the defendant.
Right.
If the issues were substantially the same, if the issues at the suppression hearing was the identification of the defendant, and later on the same issue was at trial, whether or not this defendant was the one that actually committed the crime, I would absolutely agree with Your Honor that that is admissible. However, under the same, if you change that hypothetical a bit, or under the case law, if you change that to a suppression hearing where the issue is the probable cause to arrest, and then later on at trial the issue is the guilt or innocence of the defendant, then in that context, Your Honor, I would suggest to the Court that the issues are not similar. Therefore, the motivation to cross-examine would not be the same.
Okay, so maybe the motivations are different, but shouldn't we actually look to what happened at the bail dangerousness hearing to see if, in fact, defense counsel did indeed cross-examine the witness on bias, prejudice, on the circumstances, on her memory, and things of that sort. And isn't that what happened here?
Yes and no, Your Honor. It did happen to some extent. However, I would suggest to the Court, because the motivation was lacking, because of the distinction between the issues at the dangerousness hearing and the trial, the areas that should have been probed and would have been probed were not. For instance, the very credibility and motive to lie of this victim or this complainant were not probed into. Very slightly, and during the course of the argument is the first time that the defense counsel said there was a history in the past where the claims have been brought by this complainant and then later on dismissed and recanted. That was in the course of the argument, and I know that my brother had referred to that as one of the arguments, but that argument is not heard by the jury. And if this was a trial, then this precise motive and past conduct of this complainant would have played a key role in the cross-examination and showing that this complainant, this was her modus operandi, this is what she did, and therefore directly affect her credibility during the course of the trial.
Certainly the defendant at trial would be able to introduce the kinds of material that he could have used to impeach the witness. So in other words, if there was evidence that the witness, who's now dead, had made false allegations against the defendant before, that would be admissible at the trial, right?
That's correct, Your Honor. Yes, sir.
Right. Well, did that happen here?
Not during the course of the trial, because the complainant was deceased.
But no, that's what I'm saying. But if there was other evidence that had happened, that would certainly be admissible at trial.
Yes, Your Honor.
But didn't we rule in a case recently, it seems to me, that if somebody is testifying by prior testimony like this, I think we ruled that then something like some prior convictions or something could come in to impeach that testimony.
Correct.
I think we ruled that. So the defense had the option to impeach this testimony by other means, even though it was recorded testimony.
Now, whether or not that case was in effect at the time of this cross-examination or at the time of the trial,
It would have been open to the defendant to argue that before the judge anyway.
Can we move to the other question? Because, of course, we have this prior recorded testimony. That's one category of things that was admitted at trial. But was also admitted at trial were statements not under oath and not part of testimony that she made to the police when they showed up at the assault.
Precisely.
And also the next day. Is that right?
The same day, but a few hours later, and then there was a written testimony. There was a written statement the next day. Yes, Your Honor, but that was not actually part of the trial. Explain
to me leaving the testimony aside, what other statements that the victim made were offered into evidence at the trial? Okay. The testimony that the victim made when the police arrived, at the time of their arrival, she started by saying, I can't take it anymore. This time I'm going to court.
So an officer testified to that?
Yes,
right?
The officer did testify to her saying that to him upon his first arrival. Now, we suggest to the court that this, sorry, let me backtrack a bit. The trial judge allowed this testimony in over the objection of the defense counsel under the excited utterance.
Did that come in at did those statements to the police come in at the 58A hearing?
The police officer was starting to testify and get cross-examined where the trial judge stopped him and said, this is a dangerousness hearing and not a trial. So that part was cut short during the dangerousness hearing. However, that officer was present and did testify to those exact statements during the course of the trial.
So that's the first set of statements are that when the police officer showed up, she made statements to the police officer. At the trial, then the police officer testified as to what she said.
Exactly.
Then
yes.
What was the next set of statements that went in?
The next set of statements was that they testified how they revived or tried to revive the other complainant, and then 5 and 10 minutes had passed, and they went back to the first complainant, Ms. Bouvier, and started having a conversation with her about what had happened. So, again, that conversation was about when we started drinking, where we were when we started drinking, then we came over here, we started drinking some more, defendant went out for more drinks, I sent him out for more drinks, came back, et cetera, et cetera.
So
that came into evidence, and that is exactly the second issue, being that statements being testimonial in nature.
Anything else? Just those two statements came into evidence?
No, Your Honor. It's the evidence in its entirety, the entire conversation of Ms. Bouvier with this police officer retelling what
I understand, but you misunderstand. Maybe I'm asking my question so well. There's one conversation as soon as the police show up, 5 or 10 minutes, there's another conversation.
That's correct.
Both of those conversations come in at trial. Any other conversations occurring later on, did they come in at trial?
Yeah, there are excerpts of conversations where she was being taken to the dangerousness hearing by a state trooper, statements saying she was sick, she wasn't feeling well, she was not going in. Statements of those natures had come in during the course of the trial, but the substantial damage was done by the testimony of the police officer arriving at the scene.
Okay,
Now, I'm sorry.
No, go ahead.
Just let me finish this if I can. But the defense counsel at the 58A hearing had those statements, and he could have used them to cross-examine her, correct?
That's correct. The
And he
defense
did use
counsel
them. He actually did use them to cross-examine.
In some, yes, to some extent he did. Yes, Your Honor.
Now, the statements that she made that you say were testimonial, why aren't they just cumulative of what came in the prior recorded testimony?
Some of the statements that she made to the police officer at the time of their arrival were recanted during the course of the dangerousness hearing or somewhat less effective. When he first came in, when the police officer first came in, she made the statement of, I can't take it anymore, he's done this before, I'm going to court this time, versus during the course of the dangerousness hearing, she somewhat downplayed a lot of these statements, saying I was drunk, I can't really remember. Again, statements that came into the police officer was he hit the other complainant so hard that his head made a dent in the wall. During the dangerousness hearing, she said, I really didn't see anything. He hit it, he took the phone away, and they both walked away rather than hit the other person being knocked out of the wheelchair.
So these statements added a lot to her prior testimony.
Exactly, Your Honor.
A lot of detail.
Yes, Your Honor, and that is the exact base of the prejudice caused by the introduction of inadmissible evidence. I see I'm out of time, and if Your Honors don't have any questions, I will rest on my brief.
Thank you, Mr.
Thank
Mond. Excuse me, Mr. Glester, good morning.
Before you get all warmed up, tell me, what were the judge's findings at trial as to the evidentiary basis to admit Ms. Bouvio's statements?
Not the recorded ones, but her statements to the police?
Her statements to the police. Did she make any rulings as to on the basis of the rules of evidence how that came in?
There were two motions in limine before trial to admit the prior recorded testimony and to admit the statements to the police as spontaneous utterances.
So she found the entirety of all of that to be a spontaneous utterance?
At least the relevant part to which the police officer testified was a spontaneous utterance and admissible because of the prior cross-examination of the 58A hearing.
But those are two different reasons.
Yes, but
Both tests have to be passed, as I recall.
yes, it had to be a spontaneous utterance, but the confrontation clause had to be satisfied.
When you say there was cross-examination on him or the opportunity to cross-examine?
Both. And the 58A hearing provided cross-examination for the substance of what happened on March 21st and March 22nd, 2005, as well as the ability and the opportunity and actual cross-examination about the victim's statements to the police.
But let's imagine that Ms. Bouvio had not died, and let's imagine that she was testifying. And how would you get in the statements that were made to the police officer, not when the police just arrived, put that aside, but after the incident with Mr. Klug, after 5 or 10 minutes had passed, and later on that day? How would that be admitted if she were alive and testifying?
If she were alive and testifying to that effect, there would have been no need to call her, and it may not have been.
Let's assume it.
Put aside the confrontation clause issue. I'm just asking about the rules of evidence. I mean, it's hearsay. It's an out-of-court statement. How would it come in?
By the prosecutor.
By the prosecutor calling the police officer to testify that the police officer had heard
What would be the basis to get around the hearsay problem?
spontaneous utterance.
Yeah, but then you answered the question that the whole statement comes in, and Justice Gantz is focusing on the second part.
Which wasn't spontaneous.
Assuming that the first part was spontaneous.
There was a two-part conversation with the police officer separated by only 5 to 10 minutes. During the 5 to 10 minutes, the male victim keeled over and needed to be resuscitated. Another startling event that left the female victim crying and in no capacity to fabricate anything, and she spoke along the same lines as her previous statement just 5 to 10 minutes before.
So you're saying if we look at the record, the entire thing comes in as a spontaneous utterance?
Yes, both parts of her oral statements that night to the police.
And did the judge, excuse me,
I'm
just
sorry.
a minute, and did the judge make that finding?
I don't think the judge made as fine a distinction as could have been made between those two separate ones. One reason may have been the second part of the statement was less detailed and corroborated the first.
So you're saying, I take it, in response to Justice Gantz's question, if I understand you, you're saying that if she had testified at the trial, Ms. Bovio, because she testified at the trial, her statement to the police officer, her hearsay statement to the police officer would come in through the testimony of the police officer because it is an excited utterance.
Yes.
The Sixth Amendment problem goes away once she exposed herself to cross-examination at a trial.
Right, whether she testified for or against the Commonwealth, whether she testified consistent with the 58A hearing, or whether she recanted it.
So she's not available to testify at trial. She testified at the probable cause hearing. These statements could have come in at the probable cause hearing.
58A, is that what you mean?
Yeah, at the 58A hearing. These statements could have come in at the probable cause hearing under the same theory. Did they? Did they come in in the dangerousness hearing?
I don't think so. I think that she testified substantively and in detail, and the Commonwealth had the police officer available, but did not testify to those statements.
But you're saying, nevertheless, that just because she did testify at the dangerousness hearing, that made the Sixth Amendment issue go away forever as to her hearsay statements to the police because they were excited utterances.
In this particular circumstance, yes.
Doesn't that seem like a gotcha? I mean, the defense counsel isn't going to... Why would he bring them up at the dangerousness hearing? What would be the possible... If the prosecutor doesn't get into them, what would be the possible reason the defense counsel would in order to cross-examine on them?
Hypothetically, I don't know, but in this particular circumstance, the prosecutor did ask the female victim specifically whether her statements to the police that night were truthful, and she answered yes. And although one of the victim's written statements did not go to the jury, the defense lawyer did cross-examine her about her written statement to police at the dangerousness hearing, demonstrating that he had the motive to examine her credibility in her statements to police, even if that statement was not ultimately given to the jury.
Did the statements go to did the written statements, were they admitted as an exhibit at trial?
They were not, but the defense lawyer at the 58A hearing did cross-examine the victim about them, demonstrating that he had the motive to examine her credibility during that hearing.
And the fact that the judge cut it off and said this isn't a trial, we just ignore that?
Well, that was the police officer's
No,
testimony.
I understand
was
that.
cut off, right?
No, that was during cross-examination, as I read the transcript.
Well, the judge's statement, this is not a trial, can we move on, came after extensive cross-examination by the defense lawyer of the female victim.
Well, it's however many pages it is.
It's a
I mean, maybe I'm just looking at, the thing on...
Well, a paraphrase of the extent of the cross-examination occurs on page 30 of the Commonwealth's brief. The judge's comment that this is not a trial demonstrates that the defense lawyer did see it as a trial-like proceeding with comparable motivation to cross-examine, and the same questions along the lines that would be asked at a trial were asked in extensive detail.
Mr. Bressler, is it so clear that the Sixth Amendment actually attaches to the 58A hearing? That
the cross-examination at the 58A hearing provided the satisfaction of the Sixth Amendment Confrontation Clause.
Did the Sixth Amendment attach? Does it actually apply to the Section 58A hearing?
Aside from whether the testimony is used later at trial.
Yeah.
It might, but the statute, of course, requires cross-examination, and so...
Yeah, but we're saying, your theory is that the Sixth Amendment goes away. The Sixth Amendment issue goes away forever by virtue of her having testified at the 58A hearing. And I'm asking, does it even attach at the 50? How can it go away if it perhaps never even attached?
Well, the case law talks about the opportunity to cross-examine, and if the defense lawyer decides...
Yeah, but that doesn't necessarily mean that the Sixth Amendment attaches.
That's correct. So I'm suggesting that the Sixth Amendment may not attach at the 58A hearing because a defense lawyer doesn't necessarily have to engage in cross-examination.
Now, is there some complication of the fact that you're allowed to offer hearsay at a 58A hearing? Does that change our equation? You're not allowed to offer it at trial?
Presumably, the evidence at trial would have to meet the two tests, both an exception to hearsay and the Confrontation Clause test. So, presumably, it could provide a bar, could provide a complication.
So, in other words, if in fact Ms. Bouvier was asked questions which elicited hearsay testimony, there could have been an objection to that being admitted at the trial.
Yes.
But that wasn't done here, as I understand it.
That was not done here.
It was the thrust of Justice Botsford's question.
So, for instance, the questions that about all the, has he hitched before, too many, all that, an objection could have been raised at trial, correct?
Yes.
Because it's relevant to the dangerousness, but it's got a lot of problems, but it may definitely be inadmissible at trial, wouldn't you think?
Some parts of her statement to police could have been inadmissible, but the main parts which the Commonwealth was pressing at the trial was simply that the defendant hit me, is what the defendant said.
But the whole thing was read, all of it, wasn't it? Or wasn't it? I mean,
well, if you're talking about the dangerousness hearing, my understanding is that excerpts of the dangerousness hearing were read to the jury. The transcript was marked for identification and appears in the Commonwealth's appendix, but it was not submitted to the jury.
Oh, so this, because Ms. Simon said that she thought the entire direct and cross of Ms. Bouvier was read. You don't think so?
Excerpts only is my understanding.
Okay.
And during the excerpts, or during the time that whatever was read to the jury, did the defense attorney object to specific questions? I know that was asked of the defense attorney, but...
Not that I'm aware of. It was the jailhouse tapes that were read in their entirety, rather than the 58A hearing.
Okay.
But there was an objection to the offering of the transcripts, wasn't there? The transcripts of the prior recorded testimony?
Yes. There was an objection during, certainly there was an argument against it during the motion in limine before the trial, and the defense wanted to keep that testimony out.
Now, you said that Officer Crispin did not testify at the dangerousness hearing, but I see here on page 52 of our appendix that he indeed did. He testified at the hearing.
Well, I believe it's his testimony which the presiding judge limited cross-examination, saying that it was not a trial.
Yes.
So it was during his cross-examination that was limited, not...
He testified, didn't you? I'm sorry, but I thought you said that the officer testified but didn't go into the statement. Isn't that what you said? At the dangerousness hearing.
Well, my understanding is just the statements to the officer were just not as detailed as the victim's actual statement at the 58A hearing, or I'll say that, at the 58A hearing.
I guess that goes back to my question. At the dangerousness hearing, the defense counsel had an opportunity to cross-examine the officer as to those statements because hearsay comes in at a 58A hearing. Why would that same defense counsel be questioning her about statements which he has a chance to cross-examine Hurley, Officer Crispin about. And the difference is that at trial, he would not be allowed generally to offer those statements, so the focus of the examination would be on the witness. Here, he could have challenged the officer's version or memory as to what occurred. Why is it the same? You're treating it as if it's the same. I guess my question is, at the dangerousness hearing, the defense counsel would have had the opportunity to question Officer Crispin about what the witness said. At a trial, if she were present, Officer Hurley would generally not be allowed to testify to what she said because it would be hearsay, and therefore the focus of the questioning would be on the witness. It seems like it's a different strategic position for defense counsel when you allow hearsay to come in at one proceeding and not at another.
The strategic position of the defense counsel was revealed at several points during the 58 hearing, including during the closing statement in which the defense lawyer said that the victim had recanted testimony against the defendant many times before. The defendant's lawyer here has told you that that statement went to the judge but not the jury. The larger point is that the defense lawyer had a motivation to try to undermine the victim's credibility at the 58 hearing through cross-examination directly of the victim and cross-examination indirectly of the police officer about her statements and her demeanor and state of intoxication at the time she made them. Following up on another comment by the defendant's lawyer here, I want to point out that evidence of recantation or alleged recantation by the victim did come in, namely the jailhouse conversations in which the victim said 3 or 4 times that you didn't hit me, and provided all the alleged reasons why she had been forced to testify against the defendant.
Thank you, Mr. President.
Thank you.